I have my friend, attorney Jasmine Greer, and lawyer in the studio. Let me just give you a little bio of my friend Jasmine. Attorney Greer is owner of Greer Law Firm, serving clients since 2008. Services include foreclosure defense, civil litigation, commercial, residential real estate, criminal defense, family law, and other various areas of law. I ran out of paper. She does so much. Bachelor's degree and she's got a bachelor's degree from the prestigious Fisk University and a law degree from Northern University, also a member of the Ohio Bar Association. She has more degrees than a thermometer. My friend. Nice to see you, Jasmine.
Same here, Tony. Always nice to see you.
So we met a few years ago, and you had given me your card, and I had said to myself, you know what do I need a lawyer for? Right? Most people say that.
Yeah, I never heard from you for a while.
Never heard from you for probably 5-6 years, and I did need a lawyer, and I called you.
Yes, you did.
If you own a business, if you own real estate, if you have any assets, eventually, hopefully not, but you may need a lawyer. And my lawyer is Jasmine Greer. Actually, I'm going to give you time right now. If you can give out your phone number and your information, let's do that right now, Jazz.
Thanks, Tony. You can reach me at 216-218-0112. Again, that's 216-218-0112. And you can check us out on the web at GreerLawFirmOhio.com.
Perfect. So, Jasmine, let's go right into, you do real estate, let's go into evictions. It's not an easy word. As a matter of fact, I write, whenever I'm on the air, I use my black Sharpie. Well, I wrote evictions in red, because if I didn't hire you, I would have hired the mafia with the tenants that I have.
Yeah. Well, evictions can be hard, Tony. I mean, I represent landlords and tenants. Of course, landlords have a little more money sometimes than tenants, but tenants are sometimes most in need of an attorney. I know, Tony, when you came to me, you're a landlord, so it was sort of easy. If the tenant doesn't pay, that first cause is all about them staying or leaving. A lot of times the tenants are misled to believe that they can come to court on that first date and talk a lot about what their landlord did or didn't do and possibly excuse not paying the rent. But like, what happened with you, Tony, It was sort of simple. Did they pay rent or not? And nothing they said mattered after that,
and you know what my answer
we got
is?
The eviction.
Take away the cable, lower your phone bill, keep a roof over your head, because if you don't pay rent, you're not going to have any of that. That's the problem.
That's true. Now, the bigger problem, and I have to step into the shoes of being an attorney for the tenant for a minute.
Yeah, absolutely.
I grew up in East Cleveland, so when I see people that need help, although they don't have as much money as landlords, my passion is a lot stronger to help them, because I know they are more in need. They don't have as much money. They don't have as much knowledge. So a few things for tenants, and Cleveland is the most tenant-friendly place, so a lot of times the judges will sort of interject with these questions. But if you're not aware, tenants, when your landlord does collect rent every month late, they just allow that to happen, which is most likely going to be your private owners. When they do that and they come to court and try to evict you without giving you a 30-day notice to start to pay rent on time, then that eviction shouldn't go forward. But a lot of tenants don't know that. That's the one thing you can bring up at an eviction hearing. Not that your landlord didn't fix the water or nothing like that, but things like that is what a defense is at an eviction hearing.
Let's talk about that. If they do not pay rent and there's a problem in the house, you can put that in escrow, correct?
That is true.
So
that is what
goes
a
in
tenant should
escrow,
do.
and then they just keep paying rent. The landlord does not get it until it is fixed. That is correct, right?
I'm glad you brought that up, Tony, because it is important that the tenant does not withhold rent if there's some issues, that they deposit the rent. But let's step into the side of the landlord. So your tenant does escrow their money. Yes, you do have a certain amount of time to fix it, 30 days. Sometimes it can be more depending on what it is, but once you fixed it, you need to file a complaint with the court to get your money back.
But they just can't hold that money and then go into court like it happened to me and then they got evicted. So it has to go in escrow. Very
Right,
important
right.
that the courts have to keep that money until something's fixed.
That's correct. That's
Okay.
correct.
So here's another situation. That's you. You're my lawyer. I love you. I had a situation where I had a tenant with me for 2.5 years. They had supposedly slipped and fell off the back porch. Now, this didn't happen in the winter. They did this on a dry pavement. So I didn't know if they did it, if it was a true claim, if it was false. I have gotten sued. I'm in the process right now of going through that lawsuit. My insurance is taking care of it. It's very important that I still call my lawyer, which I called you. Then they said, listen, you just have to call your insurance company. They will take care of the whole proceeding in case there is an injury or an accident in the home or property.
That's true. Tony, you brought up a few issues. I think that a lot of our smaller investors are not doing, which is getting insurance on that home, especially when you have a tenant in there. For instance, if the tenant is hurt on the property, the first question is, what is my liability? I'm the owner. Am I liable to the tenant? So the law does require a certain level of negligence. Okay, so if you have a duty of care, and we all have a duty of care to others, no matter what, and you breach that duty, then we have negligence, then you're liable. So the question is, what is the duty the landlord has to the tenant for injuries? And your duty doesn't go past what the tenant can see and appreciate, and that's those known hazards. Anything that is obvious and apparent, okay? Anything that they can't figure out, then that's when the landlord could be liable. So I think the biggest thing is have insurance. And if it happens, your insurance company will defend you for free. So you don't have to hire an attorney.
Okay, great. So you're listening to Art McCoy, University of Common Sense. Do not change your radio. This is not the Twilight Zone. This is Tony Masaccio from Flashpoint introducing and actually interviewing attorney Jasmine Greer. Jasmine, what other law do you do?
So I know you mentioned in your intro that I do criminal and family, but I no longer practice those areas of law. They're pretty high stress, so I've tried to focus now my practice just solely on business, real estate, and personal injury. As far as real estate, I know we talked a little bit about landlord and tenant, but I also represent a lot of investors and contractors. And I wanted to talk a little about some of the issues that contractors can run into when they're doing either home construction or home improvements. So I think general knowledge is that you can file a mechanics lien if you're not paid. But the question I think a lot of contractors don't answer is there anything I need to do before I file my mechanics lien? And that does depend a lot on what the owners have done before they've actually contracted with you. So for instance, if the owner files a notice of commencement of work, that's the owner, part owner, the person that leased with the owner and is hiring you to do the work. And I know, Tony, you own a window cleaning business,
I
right?
do, that is correct.
So if
And I have liability insurance, which is very
that's good.
important.
That's good. Licensed and bonded.
And licensed and bonded, and that's why there's people out there to actually give a lower price. It's a great commercial. Thank you very much, Jazz. That's why there's people out there that will always give a lower price because they're not insured, they're not bonded, they don't pay the taxes. So I'm losing a lot of business because you're undercut it.
That's true. So
Because
have
you're
you
not a legal
ever,
business.
have you
Correct.
ever, Tony, done any work for a general contractor?
I have, absolutely.
Home improvement?
Absolutely.
Home construction?
Absolutely. We
So-
do construction cleanup.
So,
AssuredWindowCleaning.com, 440-237-5991.
Don't miss an opportunity for a plug, Tony. So when you do a job, hopefully you always get paid.
Yes.
But say, for instance,
And if
you
not,
don't get
I'm
paid.
calling my friend Jasmine Greer.
Well, as a subcontractor, your rights are a little different than the general contractor because you don't have a contract with the owner, most likely. So you're not
That's
in
correct.
privy
Yes.
with the owner. So there are some things that you have to do that the general won't have to do if you want to get paid if all else fails.
Sure.
So again, if the owner has filed a notice of commencement and you're aware of that, and you ask for a copy of that and so on, and then you're not paid, before you file a mechanics lien, you would have had to file a notice of furnishings, of materials, or whatever it is that you furnished when you were doing with the windows. And that's the way you would perfect your mechanics lien. A little different, again, for the general, because they're in privy, they don't have to file the notice of furnishings. So, again, some things that some people don't know that I think is less common knowledge is that notice of furnishings.
I just got to tell the audience, as you can hear the knowledge of this young lady, you got to take down her number. Go ahead, Jazz, give it to me one more time.
Thanks, Tony. Again, the number is 216-218-0112. And again, check us out on the web at GreerLawFirmOhio.com.
If you do not have a lawyer, or if you have a lawyer, guess what? Someday, hopefully not, but someday you may need a lawyer. Make sure you keep that number in your phone, because you never know. Just like I went through the experience of 5 years ago, I met you and I needed you. I actually have used you a couple times in the courtroom. This girl is 5'2" with heels on, and she's like a bulldog. So whether she takes the plaintiff or the defendant side, make sure you get her first.
But I'll give you my perspective. If I were the attorney on the landlord side, that notice, if I was trying to get rid of a tenant, would have to be a 30-day notice if they're a month-to-month tenant. And that's pursuant to the law. I can cancel the contract so long as the lease doesn't say otherwise with that 30-day notice if you're month-to-month. So long as that notice is given with the actual due date of your rent. So if your rent's due on the 1st and you get that notice on the 1st, then the landlord's done their job. But if, say for instance, your rent's due on the 1st and you get the notice on the 8th, the landlord cannot evict you in that month. They could not make you move out until the next month, and they couldn't give you a 3-day notice until that next month was over. So again, I don't know exactly what your letter states, but landlords do have a right to end a contract with a 30-day notice in most circumstances, because most people pay their rent on a monthly basis. And again, disclaim the fact that I don't know what your lease says, if there is a lease. Those terms may control, but the Ohio Revised Code allows for a 30-day notice. And that sounds like what happened in your situation, that they canceled the contract.
All right.
Caller, how long have you lived in this house?
31 years.
31 years. You've been renting for 31 years in this home.
Yes.
And had you reported anything to the landlord? Do you know if there is any reason that that landlord would have wanted to give you a 30-day notice?
Is he selling the house? Do you know if he's selling the house or if it's foreclosed?
I don't know.
Okay.
How would he? Can she find that out
I will have
through the
to
courts?
check that out then.
Yeah, you can definitely go on the Cuyahoga County Clerk of Court's website, or you can go to the county auditor's website, and either the clerk's office will show you foreclosures, but if that property has actually changed hands already, then the auditor's page would show that there's a new owner. But I would, if there's any reason, for instance, if you reported a problem in the house, and maybe the landlord just feels like this tenant is a problem, I don't want to fix stuff there, and they give you this 30-day notice, it may be retaliatory, which is not something a landlord can do, and that 30-day notice could lead to a lawsuit if, again, that action was retaliatory.
Jasmine, if there is a foreclosure, would they not put the paper right on the door anyway?
They don't have to.
They don't have to.
There's no law that
okay.
requires the owner to notify the tenant. What will happen is that the new owner will come along. If they don't want you there, they'll give you a notice to vacate. And if you're not gone, they can give you a 3-day notice and evict you under color of title, because you don't have a contract with them. And they don't have to honor the contract you had with the prior owner.
We had a situation a year ago, and a young lady, basically her apartment, they wouldn't fix the issues that was wrong with her house, and they decided not to renew her lease, even though she kept paying, and they basically put a Band-Aid on the problem. She had pictures, she took it to court, she lost the case, and everything like that. What can you give us maybe your perspective from that? Because we've seen the pictures, we went to the place, they've been trying to fix it for over a year. They did a shoddy job on the maintenance intentionally, so she wouldn't be there, and they didn't renew her lease even though she paid every month.
Okay, so the first response I have to that is if the tenant who had the problems did not pay the rent because of the problems, then that landlord had every right to file that eviction for non-payment of rent. So, of course, like we said earlier, the process would have been to escrow that money. But, again, every court is different. And in the city of Cleveland, I've seen a lot of times certain magistrates will allow you to testify about certain problems. If they're egregious enough, then they will make sure that that landlord is, I guess, not notified, but they may be sent to the city department to have them come out and inspect and things like that. So that doesn't happen in almost any other city but Cleveland. But that's my first response, again, about the rent payment. And again, it could be egregious enough to be a defense to the eviction, but it has to be really bad. I mean, like no heat in the winter for months.
She didn't get evicted, and
Okay.
she paid on time every
So when you
month.
say they won, do you mean they won because they didn't have to pay her?
Well, they didn't do the maintenance properly consecutive times, and they didn't want her there.
When
So-
you say she lost, tell me what you mean.
Because
by
she
that.
wanted to stay there.
Okay.
She paid her rent. It was in a nice area.
Okay, so
she
when
was
you
an
it wasn't in
African-American
court?
woman. Huh?
It was not in court. She never ended up in court.
She went to court. I can't remember the particulars, but
Okay.
she had to leave even though she was paying rent, and they decided to not renew her
Um,
lease.
it sounds like there might be some facts we're not aware of.
Okay.
So it's hard for me to really give my opinion. So that caller was concerned about how that could happen. How can she be put out when she's never paid rent late?
And first
So-
of all, if you have a landlord, they've been there for 31 years. I would have loved this lady. I would have paid her to stay longer.
Yeah, I think you were on the right track, Tony, in assuming that there might have been a new owner. If she
Correct.
doesn't own it, of course, a lot of these places that
But
have
why
been
wouldn't
there
they say
forever.
it? Why wouldn't they tell them, hey, listen, we have a new owner. You know, we're selling the house, which happens also,
I mean,
right?
embarrassment. A lot of times
Okay.
people don't say something when they're in foreclosure because of personal issues.
Great point. Okay.
Yeah. But again, to get back to a lot of things he said, first of all, he's not an attorney. And just a disclaimer, none of this is legal advice. And your situation is always factually based, but the law is the same unless it changes. And every court is different, like I said. And I'm not sure if he's ever in Cleveland, but in Cleveland, they will give the tenants 14 days.
Okay.
In Garfield, they'll give them 14 days.
So is it
That's
always
by
like-
agreement of the parties.
And is it always a 3-day, though? As soon as it's on there,
Well,
you have a
so
3-day
let's
notice
get
to
back
leave?
to that issue. 3-day notice is served when there's a breach of the contract,
And
because it's a less notice than a 30-day notice.
Let me fast forward on that.
Mm-hmm.
Do they ever leave in 3 days?
Yes,
They
some
do.
people do.
Mine
Yeah.
mine
And you
never
can't
did.
evict someone if they're not there. So that's a good point you bring up, Tony. If the tenant has left, you can't evict them.
Sure.
But if you do file the eviction and they come to court and say they don't live there, the court's going to dismiss it. I had that come up, actually. The lady was there. I know because I actually rode past the house
Okay.
because we had given her some time to move out. Sometimes you can mediate, so you'll work out an agreement and give that tenant time to move, maybe help them so they don't have an eviction on their record. But the tenant has to leave at that appointed time. And she didn't leave, but she came to court and said she was gone, didn't have the keys. So that's like the universal way to say I'm gone is to get back the key. She didn't have the key, didn't get back the key.
Okay.
So that was a pretty crazy situation where you had the tenant saying, I'm gone, but you know they're still there. But you can't evict someone if they're not there.
I had a
My company slogan, I never knew what it would be, but I've been practicing now for about 8.5 years. And what I've come to find about my company is that it's like a family. when I help clients, they sort of become more of a friend, more family, than just a client. So, I thought, okay, that's going to be
What's your next step, Jazz, in law?
Well, Tony, like I said, I just recently decided to not take on criminal and family law. So that,
Is that
next
because-
step has already began.
Can I say because you don't get paid? You don't get paid?
Oh, that is one of many reasons why I don't
Criminal's
do
gotta be a
criminal and
tough
family
one.
law. Well, I'm very passionate about what I do, and so when I take on cases like criminal and family law, they are very intimate. I mean, you're facing losing your liberty, or you're having an issue that involves your child, and that is high stress. I have 3
Absolutely.
kids.
Yes.
My kids are 14, 8, and 2. I do not want to have stress from my job because I just need to make sure I'm okay for them. So with real estate, business, and personal injury, yes, there's still a little stress, but it's not the type of stress that comes with those sort of more personal, more intimate things like criminal and family law.
You know, I've heard of cases where people that they've not owned the home. I just heard about this, where they not own the home and they would pretend like they were taking rent from somebody, right?
Mm-hmm.
And they would, person thought they're coming in, they're moving in, they got their first deposit, they got their rent. They don't have a house. It's not their home. How do you protect yourself against that?
So it's interesting you brought that up because this happens a lot. And I just actually had a sit down with one of my clients, and they told me that they had encountered situations similar where the occupant had given their deposit and rent to someone that was not the owner, but that was a prior occupant. So this person was still in contract with the owner. They moved out, and it should have been a sublease, but they didn't get the owner's permission, and they
Sure.
did not inform the new tenant that they were just a tenant. They made it appear that they were the owner. So the way you protect yourself from that is to check the county auditor's webpage. It's public record. I mean, we all have our phones now, so we can all access the internet very quickly. And you can just check who owns the house. If there's a company name, you go to the Secretary of State website, you put in that company name, see who started the company. If this guy or gal who's trying to rent you the property is not on one of those information pages, then you might want to question getting into a deal with them.
All right, another question. Someone's out there. They want to be a lawyer. It's a dignified, it's a worthy profession. You guys got the worst jokes. I know that you're like beat on as lawyers.
Yes.
What do you say about those who are actually going in the field right now? Obviously, you love it. You've almost been in it for 10 years. Would you have done anything else? And
No.
what do you advise for those who are interested in going into it now?
Well, you asked the question, I want to answer that first. And was there anything else I would have done? And I have to say no. From when I was a kid, growing up in East Cleveland, that was always my goal, to become an attorney. Even when I fell in love with physics, I did not deter from becoming an attorney.
Jasmine,
So,
you're too smart. I hate you. Go ahead, John.
thank you. So as far as anyone else who wants to get into the field, it is very hard. I don't care if your client is a company or a person. The work that you have to put in to satisfy just the professional responsibility that we have is tough. So if you want to be an attorney, be ready for the work. It's not something you can gloss over or be mediocre at. Even the best attorneys are still probably not great, but we have to try as hard as you can to be the best you can. But you cannot think that this is an easy thing. I know a lot of people I meet, I can be an attorney because I argued well at this hearing this one day. But what we do is more than going into a courtroom and talking loud. A lot of what we do is outside of the courtroom, researching and writing and just making sure that we are prepared for our case.